This is the moment American democracy proved it still has guardrails that even Donald Trump cannot breach. At 4:32 p.m. Eastern on Monday, February 10, 2026, a federal grand jury in Washington, D.C. delivered a stunning rebuke to the Trump administration's most authoritarian overreach yet, unanimously refusing to indict 6 Democratic lawmakers for the crime of urging military personnel to refuse illegal orders. The grand jury's rejection represents the first time in American history that ordinary citizens have been asked to criminally prosecute sitting members of Congress for exercising their First Amendment rights. And their refusal to participate in this constitutional assault has sent shockwaves through a Justice Department that believed it could weaponize the criminal justice system to silence political opposition. The 6 lawmakers targeted for prosecution read like a roster of American patriotism. Senator Alyssa Slotkin of Michigan, a former CIA officer who served multiple tours in Iraq; Senator Mark Kelly of Arizona, a Navy combat pilot and NASA astronaut; Representatives Jason Crow of Colorado, a former Army Ranger who served in Iraq and Afghanistan; Maggie Goodlander of New Hampshire, a former Navy intelligence officer; Chris DeLuzio of Pennsylvania, a Navy veteran who served in international waters; and Chrissy Houlihan of Pennsylvania, a former Air Force captain and chemical engineer. These are not radical activists or anti-government extremists. These are decorated veterans who dedicated their lives to defending American democracy, both in uniform and in Congress. Their crime, according to Trump's Justice Department, was producing a 90-second video in November 2025 that warned military and intelligence personnel that threats to our Constitution are coming from right here at home and urged them to refuse illegal orders. The video was prompted by Trump's increasingly authoritarian rhetoric about using military force against American citizens and his repeated threats to deploy federal troops in Democratic-controlled cities despite legal prohibitions against such domestic military action. The lawmakers' message was simple and constitutionally sound. Military personnel take an oath to defend the Constitution, not to obey a commander-in-chief who orders them to violate that Constitution. For this act of patriotic duty, Trump's Justice Department sought to destroy their lives and careers through criminal prosecution. The timeline of the Justice Department's assault on these lawmakers reveals a systematic campaign of intimidation that began within days of the video's release. According to leaked DoJ communications obtained by multiple news outlets, Attorney General Pam Bondi personally ordered the investigation after Trump called her in a rage about the video during a late-night phone conversation on November 15, 2025. Trump allegedly told Bondi that the lawmakers were committing treason and demanded immediate arrests. When Bondi explained that criticizing the president is not treason, Trump reportedly screamed that he didn't care about legal technicalities and wanted the lawmakers destroyed before the 2026 midterm elections. The investigation was assigned to Jeanine Pirro, the former Fox News host whom Trump installed as a senior DOJ prosecutor, despite her complete lack of federal criminal experience. Pirro's appointment was itself controversial, as she had spent years on television defending Trump's legal troubles and attacking the very prosecutors she now works alongside. Her selection to lead this case was clearly intended to ensure aggressive prosecution rather than objective legal analysis. The investigation techniques employed against the lawmakers crossed every ethical and legal boundary that normally constrains federal prosecutors. According to sources familiar with the case, DOJ investigators conducted surveillance of the lawmakers' families, monitored their communications with constituents, and attempted to pressure their staff members to provide information that could be used in criminal charges. The department also tried to obtain privileged communications between the lawmakers and their attorneys by claiming that discussions about the video constituted conspiracy planning rather than protected attorney-client communications. Most disturbingly, investigators attempted to use classified materials to entrap the lawmakers by inviting them to briefings where they would be shown sensitive intelligence information and then questioned about whether they still believe military personnel should refuse illegal orders. This tactic was designed to create a catch-22 situation where the lawmakers would either have to abandon their constitutional principles or be accused of encouraging insubordination with access to classified information. The lawmakers saw through this trap immediately and refused to attend any briefings or interviews related to the case. Senator Slotkin captured the essence of the Justice Department's strategy when she issued a public statement saying, "The intimidation is the point, and I'm not going to go along with that." Her refusal to legitimize the investigation became a rallying cry for the other targeted lawmakers who coordinated their response to ensure that none of them would provide the Justice Department with any cooperation that could be twisted into evidence of wrongdoing. The legal theory underlying the prosecution was so constitutionally frivolous that multiple former DOJ officials, including Republicans who served under previous administrations, publicly condemned the investigation as an abuse of prosecutorial power. The department's argument centered on the claim that urging military personnel to refuse illegal orders constituted seditious conspiracy and inciting rebellion against the United States government. This interpretation of federal law was not only legally groundless, but historically ignorant, as American military law explicitly requires personnel to disobey unlawful orders and provides legal protections for those who refuse to participate in illegal activities. The Uniform Code of Military Justice, which governs military conduct, states unambiguously that military members have a duty to disobey orders that are patently illegal. The Nuremberg trials established the principle that following orders is not a defense for participating in illegal activities, and this principle has been incorporated into American military training and legal doctrine for decades. The Lawmakers video was essentially reminding military personnel of their existing legal obligations, not encouraging them to violate their duties. Former military lawyers who reviewed the case noted that, if anything, the lawmakers were helping prevent the kind of illegal military actions that could result in courts-martial for service members who participated in them. The grand jury proceedings themselves provide insight into how ordinary Americans react when asked to participate in political persecution. According to sources familiar with the grand jury process, prosecutors struggled from the beginning to present evidence that would support criminal charges. The grand jurors repeatedly asked pointed questions about how urging compliance with existing military law could constitute a federal crime. Several grand jurors reportedly expressed confusion about why the Justice Department was seeking indictments against people who appeared to be defending constitutional principles rather than attacking them. The breaking point came when prosecutors showed the grand jury the actual video that formed the basis of their case. Rather than seeing evidence of seditious conspiracy, grand jurors saw decorated veterans expressing legitimate concerns about constitutional violations and reminding military personnel of their legal obligations. According to leaked grand jury communications, one juror asked prosecutors directly, "Are we really criminalizing people for reading the Constitution on camera?" When prosecutors could not provide a satisfactory answer to that question, the grand jury's willingness to cooperate with the investigation collapsed. The unanimous rejection of all proposed indictments represents more than a legal victory for the targeted lawmakers. It demonstrates that American democratic institutions retain the capacity to resist authoritarian overreach when citizens are asked to participate directly in the process. Grand juries represent one of the few remaining checks on prosecutorial power that does not depend on political appointees or partisan loyalty. When ordinary Americans are presented with evidence and asked to make decisions based on law rather than politics, they still recognize the difference between legitimate law enforcement and political persecution. The Justice Department's response to the grand jury rejection has been revealing and desperate. Rather than accepting that their case lacked merit, department officials have begun exploring alternative prosecutorial strategies that would bypass grand jury oversight. According to sources within DOJ, Jeanine Pirro has proposed using federal civil rights statutes to charge the lawmakers with conspiracy against rights, a Reconstruction-era law designed to prosecute Ku Klux Klan members who intimidated black voters. This proposed use of civil rights law represents an inversion of its intended purpose, as Pirro would be using legislation designed to protect democratic participation to prosecute people for encouraging constitutional compliance. The department has also explored using military justice procedures to prosecute the lawmakers, despite the fact that none of them are currently serving in the military, and military courts have no jurisdiction over civilian legislators. These desperate legal theories demonstrate that the Trump administration is so committed to persecuting these lawmakers that it will twist any available statute to achieve political goals, regardless of legal precedent or constitutional limitations. The broader implications of this prosecution attempt extend far beyond the 6 targeted lawmakers to threaten the fundamental relationship between civilian government and military forces. The principle of civilian control of the military depends on the ability of elected officials to provide guidance and oversight of military activities, including the authority to criticize military policies and remind service members of their legal obligations. If members of Congress can be criminally prosecuted for discussing military law with military personnel, then civilian oversight becomes impossible, and the military effectively becomes accountable only to the executive branch. This transformation would represent the end of democratic government and the beginning of military dictatorship, as the president would be the only civilian official allowed to communicate with military forces without facing criminal prosecution. Legal scholars have noted that the prosecution attempt also threatens the separation of powers doctrine that prevents the executive branch from intimidating the legislative branch through criminal law enforcement. The Constitution's speech or debate clause explicitly protects lawmakers from prosecution for their legislative activities, and the Supreme Court has interpreted this protection broadly to include public communications about government policy. The Trump administration's prosecution attempt violates this constitutional protection by treating policy advocacy as criminal activity, setting a precedent that could be used to criminalize any criticism of executive branch actions. The international reaction to the prosecution attempt has been swift and alarmed, with Democratic allies expressing concern that the United States is adopting the tactics of authoritarian regimes that routinely prosecute opposition politicians for criticizing government policies. European Union officials have privately warned that continued erosion of American democratic norms could affect transatlantic cooperation agreements that depend on shared democratic values. NATO allies have expressed particular concern about the prosecution attempt because it targets lawmakers who were defending the principle that military forces should obey law rather than political authority, a principle that underlies democratic military institutions throughout the alliance. The targeted lawmakers themselves have emerged from this crisis with enhanced credibility and national profiles that position them as leading voices for constitutional democracy. Senator Kelly's statement that the prosecution attempt represented an outrageous abuse of power captured national attention and established him as a prominent defender of democratic norms. Representative Goodlander's declaration that an American grand jury honored our Constitution by standing up to an outrageous abuse of presidential power provided a powerful response that framed the grand jury's action as patriotic resistance rather than simple legal procedure. Representative Crow's warning that Americans should be appalled by the fact that Donald Trump and his goons at Department of Justice and everywhere else are weaponizing their justice system just to try to silence dissent and to crush political opponents crystallized public understanding of the broader threat that the prosecution attempt represented to democratic governance. The failure of the prosecution attempt has created a template for resistance that other potential targets of Trump administration persecution can follow by refusing to cooperate with obviously illegitimate investigations, by coordinating their response to prevent the government from isolating individual targets, and by framing their resistance in constitutional rather than partisan terms. The 6 lawmakers demonstrated that even the most aggressive prosecutorial tactics can be defeated when targets stand together and refuse to be intimidated. This model of coordinated resistance may prove crucial as the Trump administration expands its use of criminal prosecution to target other political opponents, journalists, and civil society organizations that challenge presidential authority. The Justice Department's failure also exposes the limitations of prosecutorial power when cases lack legitimate legal foundation. Despite having unlimited resources, professional prosecutors, and grand jury procedures designed to facilitate indictments, the department could not persuade ordinary Americans to criminalize constitutionally protected speech. This failure suggests that other Trump administration prosecution attempts may face similar resistance when presented to grand juries or trial juries who are asked to convict people for activities that obviously fall within constitutional protection. The political ramifications of the prosecution attempt and its failure are still unfolding, but early indicators suggest that the Justice Department's overreach has backfired spectacularly by creating national attention for the lawmakers' original message about refusing illegal orders. The video that Trump wanted to suppress through criminal prosecution has now been viewed millions of times and discussed extensively in mainstream media outlets that might otherwise have ignored it. The prosecution attempt transformed 6 individual lawmakers into symbols of constitutional resistance and provided them with a national platform to warn about authoritarian overreach. Public polling conducted after the grand jury rejection shows overwhelming support for the lawmakers and strong opposition to the prosecution attempt, with even Republican voters expressing concern about using criminal law to target political opposition. The grand jury's rejection of the prosecution attempt demonstrates that constitutional protections remain meaningful when citizens understand their role in defending democratic governance. But it also reveals how close the United States has come to crossing the line into political persecution of the kind that characterizes authoritarian regimes, and how dependent democratic survival has become on the willingness of individual Americans to resist when asked to participate in the destruction of constitutional government.